Okay, let's talk about employment law. These are the objectives. So, dental hygienists as employees, remember your value and really know what your value is. It's kind of something we've said in other classes, but it's important for you to really think about and understand the contribution that you make to an office, for one, to the profession, to all of healthcare, to your individual patients. So, really kind of spend some time thinking about what you do and how you make a difference in people's lives, and be proud of that and value it and expect your employers to value it as well. Um, Compliance with federal and state employment laws is one way for your employer to show that they value you. They should also oftentimes go above and beyond whatever the bare minimum is. You'll know pretty quickly if you are really truly valued in an office. If issues arise, bring it to your employer first. Uh, Try and keep open relationships and open lines of communication. If you are in a small practice where the dentist is your employer, the owner, your boss, everything, try and establish really good communication, and your expectations. And I think that goes a really long way to helping you find the right place of employment. It's your ethical and professional responsibility to make sure that you're being treated well and upholding that in others, making sure that others are treating you the way that they should. Because really, if you put up with something, they might be treating everyone in the office that way, but it might just take one person to say, this actually is not okay. And then they'll go, oh, I can't get away with that. And then it might improve that situation for everybody. So types of employment, there's at will and there's term. At will means that an employment relationship can be terminated for any reason or no reason by either the employee or the employer. Oregon is an at will employment state. And then there's term, which sort of has to do with a contract. Contracts could be different lengths, 3 months, 12 months, 3 years. There's usually parameters that have to do with early termination. It's basically you're locked into the contract, and you have to go by those parameters. Be familiar with your state and your federal laws. So, Civil Rights Act of 1964, there's several points here. Discrimination based on race, color, religion, sex, national origin. These are all things that we're very familiar with. Things like this discrimination, I think, have improved greatly, but we still deal with a lot of implicit bias that we've talked about in other courses. And so it's just important to be aware of these rights and to know your rights. It can also include hiring and firing and compensation and promotions and benefits and all this. The difficulty comes when we're dealing with really small private practices who may have less than 10 employees. Some of these things about breaks and vacation times and sick leaves don't always apply or are enforced in very small private practices. And so these are some of the benefits of working for larger corporations. Pregnancy discrimination. There are more men that are joining the workforce of dental hygiene, but traditionally, and especially I think when this textbook was written, there was still 90% of hygienists or something were women. So this is a big one for obviously women to think about, but men too who have children and want to go on paternity leave. Or maybe mom wants to keep working and dad wants to take the paternity leave. So it's important for everybody to think about this when it comes to the childbearing years and people who want to start creating a family together. Important for you to know that also you can't be penalized for having something happen if you're pregnant and you're working and something happens with the pregnancy and you have to go on bed rest. They cannot give your job to somebody else out from under you. And this actually happened to me as well in one of my pregnancies between my girls. that I lost, I was on bed rest and I had every intention of going back to work. And the doctor had somebody come in and and actually offered them a permanent position. And everybody in that office rallied for me and said, that is so wrong. She's dealing with the loss of a child and she's on sort of a leave. You can't offer this position. And he retracted it and apologized. But I went back to work for that practice, but I always held that in my heart as, oh my gosh, that was so hurtful and really discriminatory. And I don't think they meant it. I don't think they thought it through. Was really, I don't think that they were a bad person. They just didn't think it through. But it's important for you to know, your rights. He had no right to give my job away. I was still, that would have been a discriminatory act. So when we think about the types of employment and we talk about at will, discriminatory reasons do not apply. So yes, it's at will, but that would have been being fired for a discriminatory reason. So, Equal Pay Act of 1962 protects men and women who perform equal work. Wages cannot be reduced to equalize pay inequality. And so in 2018, there was an earnings ratio showed that women are still making less than men for the same, if we're comparing apples to apples, women are earning 45,000 roughly to men's 55,000. So I think the pay gap is closing, but we are still wrestling with that as a nation and possibly globally, I would imagine. Age discrimination. This is, again, really difficult to enforce in small private practices. So older hygienists might find, it can be easy to be discriminated in an office as an older hygienist. Not always. Some dentists are saying, oh my gosh, this person has 30 years of dental hygiene experience. I want this person. But there's also issues that come with being, stuck in their ways or not knowing new technology and not given the opportunity to learn and grow because simply of their age. But again, it's difficult to enforce in small private practices. Equal Employment Opportunity Commission. So this is the agency that one would go to if they felt that there was discrimination or federal laws were not being adhered to. Enforces the federal laws against discrimination in employment setting. May file a charge with the EEOC if you feel you've been violated. Unlawful for an employer to retaliate or take adverse action if you do file a claim. So they can't fire you just because you've filed a complaint against them. Specific guidelines and timeframes must be followed. So you have to do the research into the process and protocols if that is something that you feel is important. Family Medical Leave Act. So make available medically necessary leave to qualified employees. Again, it's difficult with our small private practices because a lot of times this benefit applies to larger employee ratios. So usually it has to do with working a certain amount of time, so a certain amount of hours. The leave has to do a lot of times with taking care of a sick child or a sick family member, or if you're sick yourself, and it can be taken intermittently, maybe so many days a week for a certain length of time. Oftentimes the employer deserves a certain amount of notice, but that can't always happen depending on what's going on in your life. OSHA, Occupational Safety and Health Act of 1970, federal law intended to ensure the safe and healthful working conditions for employees. Employers and employees must comply with these standards. We all know this. We get our OSHA training, and you'll have OSHA training every single year no matter where you work. This is just standard. It's to minimize illness and injury. Employers are obligated to provide a safe work environment. They have to comply with these standards to make a safe work environment. You can get a lot of information off of OSHA.gov. OSHA is they're responsible for administering the acts, issuing the standards, conducting site inspections, and ensuring compliance. It's almost similar, if I feel like it's almost similar to like the Oregon Board of Dentistry. They make the rules and enforce them from the law. If you are injured on the job, you need to notify your dentist or the employer and contact workers' compensation program. So as a dental hygienist, you are going to be in contact with lots and lots of people, different interactions, working, non-working. So sexual harassment and an understanding of the process and what's okay, what's not okay, and how to handle this is important for you going into all different kinds of working environments. And also things like conferences and travel and, just all the different things that might happen throughout your career. We work in close contact with our colleagues and with patients. And so this in particular makes it very important for us to understand, boundaries and what's okay and what's not okay. Harassment can come from coworkers, employers, vendors, people that come into the office, patients, or anyone that you come in contact throughout the day. It can be male or female. It can be employer, coworker, patient, opposite sex, same sex. It all can happen any which way you think about it. So it violates the Civil Rights Act of 1964, and it's defined specifically as unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. So quid pro quo is something for something. I'll, give you an extra week of vacation if you, do whatever. So you can, let your imaginations run. It could be something big and overt and obvious and, kind of like, in your face, or it could be something subtle that just doesn't feel right. A hostile environment creates an unwelcome feeling. You just don't feel at ease in a situation. Examples of hostile environments could be an unwelcome flirtation. It could be something very minor, but it's unwelcome and it makes you feel uncomfortable. Sexual conversations that you're not wanting to be a part of. Unwanted touching, displaying sexual images, intrusive questioning, or using just diminutive terms like honey, So how to handle sexual harassment? So you want to clearly say no, and you want to put it in writing and keep a copy. It's really important to draw those boundaries, and I think that is probably can be the hardest part because there are so many people that think certain things are okay that aren't, and they're not super aggressive, horrible people. They just don't realize what's appropriate and what's inappropriate. And when you make those boundaries clear, then you have said, this is not okay with me, and these are my boundaries. And if they don't respect that, that's crossing a line. But if they know, then they know to respect it. So you want to also hold the harasser accountable and not make excuses. So that can be a hard thing because if they're your employer and you know that they just joke and they're just sort of that way, it's easier to say, oh, that's just how they are. Document reoccurring incidences, date, time, and place, detail what happened, document your work performances so that you have documentation that you're a good employee and they can't retaliate and say, oh, they're always late, they lie about things, they're dishonest, blah, blah, blah. You might have to file a complaint or contact an attorney if things don't turn around and get better. I'm running out of time for this screencast-o-matic, but all of this information, breaks, vacations, sick leaves, holiday leave, working